Welcome back to my channel, Offer Accepted. I'm Candice Fontas, your local real estate advisor, and the topic today is a new law that goes into effect October 15th of this year, which removes home inspections as a contingency. Massachusetts is definitely shaking up things in the real estate world, and it could protect home buyers like never before. If you've ever felt pressured to waive a home inspection just to get your offer accepted, this new law is for you. Under the new law called 760 CMR 74, the state wants to make sure buyers are no longer forced to give up their right to a home inspection just to get in the game. In short, sellers cannot say, "We'll only accept your offer if you skip the inspection." And on the flip side, buyers cannot say, "We will skip the inspection if you accept our offer." This new law, if it passes, will make all of that illegal. And there would be serious consequences if you even hint about waiving that inspection. Let's break it down. Here's what the new rule would do. Sellers and agents can't demand a waiver. You can't be forced to directly or indirectly to give up your inspection. And if an agent tries to hint that waiving helps your offer, they would be breaking the law. 2, hidden waivers are also banned. The law also bans sneaky contract clauses that make the inspection meaningless. 3, mandatory disclosure. Before any deal is signed, the seller or the agent must have you fill out this disclosure statement in writing. Here is the exact wording of the proposed law. Pursuant to 760 CMR 74, seller warrants and represents that the agreement to purchase is not and in no event shall be contingent upon waiver, limitation, or restriction of buyer's choice to obtain a home inspection, in whole or in part. So there is no waiver, even if you volunteer it. Even if a buyer offers to skip an inspection up front, which would be breaking the law, the seller still can't accept the offer under those terms. In fact, the seller would be breaking the law by accepting such an offer and could be sued. That doesn't mean that the buyer has to actually have the inspection. It just means they cannot communicate to the seller that they plan to skip or waive this right. If the seller is aware that the buyer plans to skip the inspection, then they could be accused of breaking the law and favoring that offer over others that include an inspection. Can a contract still have any inspection language? Yep, but there are rules now. Here's the deal. The new law says you can't put anything in the contract that would make a home inspection pointless. So as long as the buyers are still allowed to get an inspection, review the results, and back out if they're not happy, you're good. What can be in the contract? You can agree on a repair cost limitation, for example. If repairs are under a certain amount, a dollar amount, then the buyer has to move forward. You can agree to limit how much the deposit gets refunded if the buyer backs out after the inspection. Also, buyers and sellers can add extra inspections to that contract, stuff like radon, mold, past soil, well water, even noise issues. Anything beyond that standard. Oh, and one more update. The inspection timeline is now negotiable. The law says the buyer gets a reasonable period of time after signing the contract. That means both parties can agree on what's fair. Just make sure the buyer has enough time to inspect, review the report, and decide if they're still in. The law says the buyer gets a reasonable period of time after signing the contract. That means both parties can agree on what's fair. Just make sure the buyer has enough time to inspect, review the report, and decide if they're still in. So, who would be exempt from this new law? There are only a few special cases where this doesn't apply. Sales at an auction, sales of new construction, sales between close family, like parents or children, sales ordered by a divorce judgment, transfer of sales for estate planning purposes, or if the buyer themselves is a licensed home inspector. Seriously. And if you signed the deal before July 15th of 2025, you're grandfathered in, and this law won't affect your contract. Now, what happens if someone breaks the rules? Failure to comply with this disclosure requirements will constitute an unfair or deceptive act of practice under the MGL law of 93A and may also constitute a violation of license law. They could face fines, license disciplines, and civil lawsuits. This law is a big win for transparency and safety. However, it does take away a bargaining chip in a competitive seller's market. Let's say you are making a competitive offer and you are using terms to strengthen your offer. Waiving a home inspection is no longer your bargaining tactic. This could be good or bad. This could be good or bad depending on your perspective. Investors planning to do a full renovation no longer have an advantage over first-time homebuyers who plan to live in the home right away. To sum it up, home inspections are back in your corner. No more pressure, no more risky waivers, just smart, safe home buying, but also no more bargaining and waiving the home inspection. If you're buying or selling a home in Massachusetts, make sure you understand this new law. Drop your questions in the comments. Hit subscribe for updates and more tips about real estate.